certain person by the name of Jeremy C. Correa was arrested for allegedly dealing shabu in Angeles City. Under the custody of the authorities, he was blindfolded, beaten, punched, and kicked in order to extort a confession from him. In a decision on March 29, 2016, PO2 Derek Jimenez was convicted under Republic Act No. 9745, or the Anti-Torture Act of 2009, and was sentenced to an indeterminate period of arresto mayor of 2 months and 1 day to a maximum of prison correctional of 2 years and 4 months. Jimenez was found guilty of torturing Jeremy C. Correa from January 11 to 12, 2012. The torture included systematic beating, punching, kicking, striking with a rod, blindfolding, and electric shock, all motivated to extort a confession from Correa. Hi, I pray for good health. This is Icicle once again, and I will be your reporter for today's episode of the Philippine Laws Dissected. Before we dive deep into the provisions of the law, let us first talk on how and why this law came into existence. Efforts to pass an anti-torture law started way back in 1986, right after the Philippines signed the United Nations Convention Against Torture. In efforts to root out torture within institutions like the Armed Forces of the Philippines and the Philippine National Police, the House of Representatives and the Senate proposed several versions of the law, which eventually gave way to the enactment of Republic Act No. 9745, or the Anti-Torture Act of 2009, signed by the then President Gloria Macapagal Arroyo on November 10, 2009. Indeed, for all its worth, torture is perceived negatively worldwide. This holds true even in the Philippines. The nation under this law ensures that torture in any way, form, and manner will never be practiced anywhere in the country. The Philippines' policy regarding torture is deeply enshrined in Section 2 of Republic Act No. 9745, where it aims, first, to value the dignity of every human person and guarantee full respect for human rights. Second, to ensure that the human rights of all persons, including suspects, detainees, and prisoners, are respected at all times, and that no person placed under investigation or held in custody of any person in authority or agent of a person in authority shall be subjected to physical, psychological, or mental harm, force, violence, threat, or intimidation, or any act that impairs his or her will or in any manner demeans or degrades human dignity. Third, to ensure that secret detention places, solitary incommunicado, or other similar forms of detention where torture may be carried out with impunity are prohibited. And lastly, to fully adhere to the principles and standards on the absolute condemnation and prohibition of torture as provided for in the 1987 Philippine Constitution. Various international instruments to which the Philippines is a state party, such as but not limited to the International Covenant on Civil and Political Rights, the Convention on the Rights of the Child, the Convention on the Elimination of All Forms of Discrimination against Women, and the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment, and all other relevant international human rights instruments to which the Philippines is a signatory. In this segment of the episode, we will now be defining specific words and provisions that are relevant in our discussion of this act. So let us start with torture. What is torture? Section 3 of Republic Act No. 9745 defines torture as first, an act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or her or a third person information or a confession. Second, punishing him or her for an act he or she or a third person has committed or is suspected of having committed or intimidating or coercing him or her or a third person. And lastly, for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent or acquiescence of a person in authority or agent of a person in authority. It is important to note that, however, torture does not include pain or buffering, arising only from inherent in or incidental to lawful sanctions. In other words, actions taken by a competent authority in the legitimate exercise of its duty and in order to safeguard public order cannot be considered as torture. The next term we need to define is the word victim. It is important because not all victims by its common definition can be considered as such under this law. So under this law, as provided under Section 3, a victim is a person subjected to torture or other cruel, inhuman, and degrading treatment or punishment as defined above, and any individual who has suffered harm as a result of any acts of torture or other cruel, inhuman, and degrading treatment or treatment. Let's say a person comes to your office. He alleges that during the interrogation, the police officer asked him a very mind-boggling question as to which came first, the chicken or the egg. Because of this, he suffered sleepless nights from thinking too much of the possible answer. Now, he is asking you if this may be considered as torture. Well, in order to answer this question, we need to determine which acts are punishable as torture. Section 4 and 5 of the Republic Act No. 9745 enumerates these acts, which can be divided into two major classifications, namely physical torture and mental or psychological torture. The first classification, which is physical torture, is defined as a form of treatment or punishment inflicted by a person in authority or agent of a person in authority upon another in his or her custody that causes severe pain, exhaustion, disability, or dysfunction of one or more parts of the body. These acts, although not exclusive, may be the following. First is systematic beating, headbanging, punching, kicking, striking with truncheon or rifle butt or other similar objects, and jumping on the stomach. Second is food deprivation or forcible feeding with spoiled food, animal or human excreta, and other stuff or substances not normally eaten. Third is electric shock. Fourth is cigarette burning, burning by electrically heated rods, hot oil, acid, and also by the rubbing of pepper or other chemical substances on mucous membranes or acids or spices directly on the wound. The next one is the submersion of the head in water, or water polluted with excrement, urine, vomit, or blood until the brink of suffocation. Another example is being tied or forced to assume in fixed and stressful bodily position. The next one is rape and sexual abuse, including the insertion of foreign object into the sex organ or rectum, or electrical torture of the genitals. The next one is mutilation or amputation of the essential parts of the body, such as the genitalia, ear, tongue, and etc. The next one is dental torture, or the forced extraction of the teeth. And the 10th one is pulling out of the fingernails. The next one can also be harmful exposure to the elements such as sunlight and extreme cold. Then another example is the use of plastic bag and other materials placed over the head to the point of asphyxiation. Another example is the use of psychoactive drugs to change the perception, memory, alertness, or will of a person, such as the administration of drugs to induce confession and or reduce mental competency, the use of drugs to induce extreme pain or certain symptoms of a disease, and lastly, other analogous acts of physical torture. The second classification is mental or psychological torture, which is defined defined as the acts committed by a person in authority or agent of a person in authority which are calculated to affect or confuse the mind and or undermine a person's dignity and morale. These acts, although not exclusive, may be the following. One example is blindfolding. Next one is the threatening of a person or his or her relative with bodily harm, execution, or other wrongful acts. Another is confinement in solitary cells or secret detention places. The next one is prolonged interrogation. Fifth is preparing a prisoner for a show trial, public display, or public humiliation of a detainee or prisoner. The next one is causing unscheduled transfer of a person deprived of liberty from one place to another, creating the belief that he or she shall be summarily executed. The next one is maltreating a members of a person's family. Another example is causing the torture sessions to be witnessed by the person's family, relatives, or any third party. Another one is denial of sleep or rest. It also includes shame infliction, such as stripping the person naked, parading him or her in public places, shaving the victim's head, or putting marks on his or her body against his or her will. The next one is deliberately prohibiting the victim to communicate with any member of his or her family. And lastly, other analogous acts of mental or psychological torture. Republic Act No. 9745 also punishes the infliction of other cruel, inhuman, and degrading treatment or punishment by a person in authority or agent of a person in authority against another person in custody. Under Section 5, this refers to a deliberate and aggravated treatment or punishment not falling under physical or mental torture as defined in the law, which attains a level of severity sufficient to cause suffering, gross humiliation, or debasement to the person in custody. It should be taken note that the assessment of the level of severity will depend on all the circumstances of the case, including the duration of the treatment or punishment, its physical and mental effects, and in some cases the sex, religion, age, and state of health of the victim. Furthermore, the establishment, operation, and maintenance of secret detention places, solitary confinement, incommunicado, or other similar forms of detention, where torture may be carried out with impunity, is also punished and prohibited under Republic Act No. 9745. This then leads us to a question as to who may file a complaint for the acts punishable. Under Section 11 of this Act, the Commission on Human Rights and the Public Attorney's Office shall render legal assistance in the investigation and or monitoring and or filing of the complaint for a person who suffers torture and other cruel, inhuman, and degrading treatment or punishment, or for any interested party hereof. The victim or interested party may also seek legal assistance from the Barangay Human Rights Action Center nearest him or her, as well as from human rights non-government organizations. We have already identified who are considered victims to crimes punishable under torture and the persons who may file a complaint. The next aspect we need to know is who are considered criminally liable under this law. Under Section 13 of this Act, there are two types of persons that are punished. Such classification is dependent on their degree of participation in the execution of the crime of torture. They can either be a principal or an accessory. The following are persons liable as principals under this law. First is any person who actually participated or induced another in the commission of torture or other cruel, inhuman, and degrading treatment or punishment, or who cooperated in the execution of the act of torture or other cruel, inhuman, and degrading treatment or punishment by previous or simultaneous acts. Second is any superior military, police, or law enforcement officer or senior government official who issued an order to any lower-ranking personnel to commit torture for whatever purpose. Third Third is the immediate commanding officer of the unit concerned of the AFP or the immediate senior public official of the PNP and other law enforcement agencies if by his act or omission or negligence he has led, assisted, abetted, or allowed, whether directly or indirectly, the commission of torture by his or her subordinates, or he has knowledge of or owing to the circumstances at the time should have known that acts of torture or other cruel, inhuman, and degrading treatment or punishment will be committed, is being committed, or has been committed by his or her subordinates or by others within his or her area of responsibility, despite such knowledge, did not take preventive or corrective action either before, during, or immediately after its commission, when he or she has the authority to prevent or investigate allegations of torture or other cruel, inhuman, and degrading treatment or punishment, but failed to prevent or investigate allegations of such act, whether deliberately or due to negligence. The persons liable as accessories include any public officer or employee if he or she has knowledge that torture or other cruel, inhuman, and degrading treatment or punishment is being committed and without having participated in its commission either as a principal or accomplice, takes part subsequent to its commission, first by profiting from or assisting the offender to profit from the effects of the act of torture or other cruel, inhuman, and degrading treatment or punishment, or second, by concealing the act of torture or other cruel, inhuman, and degrading treatment or punishment, and or destroying the effects or instruments of torture in order to prevent its discovery, or third, by harboring, concealing, or assisting in the escape of the principals in the act of torture or other cruel, inhuman, and degrading treatment or punishment, provided the accessory acts are done with the abuse of official public functions. The state policy of this law has strictly provided that secret detention places, solitary confinement, incommunicado, or other similar forms of detention where torture may be carried out with impunity are prohibited. As such, it is important to determine which detention centers and facilities in the Philippines are considered as prohibited. As such, Section 7 provides that the Philippine National Police, the Armed Forces of the Philippines, and other law enforcement agencies concerned shall make an updated list of all detention centers and facilities under the respective jurisdiction, with the corresponding data on the prisoners or detainees incarcerated or detained therein, such as, among others, names, date of arrest and incarceration, the crime or offense committed. This list shall be made available to the public at all times, with a copy of the complete list available at the respective national headquarters of the PNP and the AFP. A copy of the complete list shall likewise be submitted by the PNP, AFP, and all other law enforcement agencies to the Commission on Human Rights, and such lists to be periodically updated by the same agencies within the first 5 days of every month at the minimum. Every regional office of the PNP, AFP, and all other law enforcement agencies shall also maintain a similar list for all detainees and detention facilities within the respective areas, and shall make the same available to the public at all times at the respective regional headquarters, and submit a copy updated in the same manner provided above to the respective regional office of the CHR. This is to ensure that agencies concerned with torture and detention centers and facilities are updated so as to safeguard the state policy with the prohibition of certain detention centers and facilities. However, the provision on prohibited detention as provided for in Section 7 is not absolute. Detention per se is not prohibited. What is prohibited are secret detention places, incommunicado, solitary solitary confinement or similar, where torture may be carried out with impunity. Imagine this. A person comes to your office and said that he was tortured by the police, who forced him to make a statement. Now he is asking whether or not his statement may be used as evidence against him in court. What would be your answer? The answer is no. Section 8 provides that any confession, admission, or statement obtained as a result of torture shall be inadmissible in evidence in any proceeding. This is because we cannot ascertain the reliability of a tortured confession, as such confession was done with undue influence and intimidation. A person will likely confess at the expense of avoiding pain or danger over one's life. Now, will your answer be the same if on the same case, such statement will be used against the police officer who perpetrated the torture? In this case, the answer is no. In this case, the statement may be used against the police officer. The exclusionary rule does not apply against the officer, as the law speaks of an exception, wherein if the same evidence is used as evidence against a person or person accused of committing torture. Now, can torture be absorbed by other crimes committed as a consequence or as a means in the conduct or commission thereof? Under Section 15, it mentions that torture as a crime shall not absorb or shall not be absorbed by any other crime or felony committed as a consequence or as means in the conduct or commission thereof. In this case, torture shall be treated as a separate and independent criminal act whose penalties shall be imposable without prejudice to any other criminal liability provided for by domestic and international laws. But may the crime of torture be subject to amnesty? But before that, what is amnesty? It is an act of the sovereign power granting oblivion or a general pardon for a past offense, and is rarely, if ever, exercised in favor of a single individual, and is usually exerted in behalf of certain classes of persons who are subject to trial but have not yet been convicted. In other words, amnesty completely extinguishes the penalty, all its effects, and may be granted even after conviction. In this case, amnesty cannot extinguish the liability of torture as provided for under Section 16 of the Act. This is to ensure that the crime of torture will not be depreciated by reason of such amnesty. Republic Act No. 9745 is a special penal law, which is distinct and different from the crimes enumerated under the Revised Penal Code. However, it is important to note that the provisions of the Revised Penal Code, insofar as they are applicable, shall be suppletory to this Act. Provisions in the RPC are appreciated. Moreover, if the commission of any crime punishable under Title 8, which is crimes against persons, and Title 9, which is crimes against personal liberty and security of the Revised Penal Code, is attended by any of the acts constituting torture and other cruel, inhuman, and degrading treatment or punishment as defined herein, the penalty to be imposed shall be in its maximum period. Republic Act No. 9745 is considered as a qualifying circumstance. Republic Act No. 9745 also provides for the refouler rule, which states that no person shall be expelled, returned, or extradited to another state where there are substantial grounds to believe that such person shall be in danger of being subjected to torture. For the purposes of determining whether such ground exists, the Secretary of the Department of Foreign Affairs and the Secretary of the DOJ, in coordination with the chairperson of the CHR, shall take into account all relevant considerations, including, where applicable and not limited to, the existence in the requesting state of a consistent pattern of gross, flagrant, or mass violation of human rights. In order to safeguard the state's policy enshrined under this law, victims of torture have rights provided by this law. These rights are the following: First is to have an impartial investigation by the CHR and other concerned government agencies such as the Department of Justice, the Public Attorney's Office, the PNP, the National Bureau of Investigation, and the AFP. Second is to have the investigation of the torture completed within a maximum period of 60 working days from the time a complaint for torture is filed, and to have any appeal resolved within the same period. Third is to have sufficient government protection for himself or herself and other persons involved in the investigation or prosecution, such as his or her lawyer, witnesses, and relatives, against all forms of harassment, threat, and or intimidation as a consequence of the filing of the complaint for torture or the presentation of evidence for such complaint. Fourth, to be given sufficient protection in the manner by which he or she testifies and presents evidence in any forum to avoid further trauma. And lastly, to claim for compensation under Republic Act No. 7309, which in no case shall be lower than 10,000 pesos and other existing laws and regulations. An important point to take note is a writ of habeas corpus or writ of amparo or writ of habeas data proceeding, if instituted on behalf of the victim of torture or other cruel, degrading, and inhuman treatment or punishment, should be disposed of expeditiously, and any order of release by virtue of such proceeding or other appropriate order of a court relative to such proceeding should be executed or complied with immediately. Lastly, it is important to know specific penalties provided by Republic Act No. 9745. It can be enumerated in 8 classifications. First, the highest penalty of reclusion perpetua, or from 20 years and 1 day to 40 years, will be imposed in the following crimes: for torture resulting in the death of any person, torture which resulted in mutilation, torture with rape, torture with other forms of sexual abuse, and in consequence of torture, the victim shall become an imbecile, insane, blind, or maimed for life. Also, for torture is committed against children. Second, the penalty of reclusion temporal, or 12 years and 1 day to 20 years, will be imposed if mental or psychological torture resulting in insanity, complete or partial amnesia, fear of becoming insane, or suicidal tendencies of the victim due to guilt, feelings or worthlessness or shame is committed. Third is the penalty of prison correctional, or from 6 months and 1 day to 6 years, will be imposed on the following crimes: torture resulting in psychological, mental, and emotional harm other than those mentioned in paragraph B, section 29, and also established to operate and maintain secret detention places and or effect or cause to effect solitary confinement, incommunicado, or other similar forms of prohibited detention as provided in Section 7 of Republic Act No. 9745, where torture may be carried out with impunity. Fourth, the penalty of prison mayor in medium and maximum periods will be imposed if victim loses their power of speech, power to hear or smell, or loses an eye, a hand, a foot, an arm, or a leg, or uses the use of any of such member, or becomes permanently incapacitated for labor. Fifth, the penalty of prison mayor in minimum and medium periods will be imposed if the victim becomes deformed or loses any part of their body other than those mentioned above, or the use thereof, or shall have been incapacitated for labor for a period of more than 90 days. 6. The penalty of prison correctional in its maximum period to prison mayor in its minimum period will be imposed if the victim becomes ill or incapacitated for labor for more than 30 days but less than 90 days. 7. The penalty of prison correctional in its minimum and medium periods will be imposed if the victim becomes ill or incapacitated for labor for 30 days or less. And lastly, the penalty of arresto Sotomayor of 1 month and 1 day to 6 months will be imposed in the following acts. First is the acts constituting cruel, inhuman, or degrading treatment or punishment as defined in Section 5 of Republic Act No. 9745, and also on responsible officers or personnel of the AFP, the PNP, and other law enforcement agencies for failure to perform their duty to maintain, submit, or make available to the public an updated list of detention centers and facilities with their corresponding data on the prisoners or detainees incarcerated or detained therein, pursuant to Section 7 of Republic Act 9745. It is evident that the anti-torture law provides legal clarity for the court, law enforcement officers, and the public on what amounts to torture. Dating back to the Anti-Torture Act's approval in 2009, only one case of torture has been taken to court, and there has only been one conviction. It has been 10 years since this landmark law came to be, and there is still much to work in changing the country's narrative of violence and degrading treatments. This ends today's episode on the anti-torture law. I hope you learned a lot. God bless everyone. Till next episode of the Philippine Laws Dissected.